ஓகேங்க. Sir, Srini sir.
Yes, sir.
Sir, speaking needs 5 more minutes, sir. Okay,
Okay, sir. Okay, sure.
okay, sir. Thanks, sir. Hi, ma'am. This is Sabarish, ma'am.
Hello, sir. I think I'm trying to connect my headphones. I'm not able to. Yeah, just a minute. Am I audible?
Yeah, ma'am. Yeah, ma'am.
Okay, just a minute, sir. The voice is little low.
Sure, ma'am.
I think there is some issue with my headphone, but still, if my voice is audible to anyone and everyone, then I can speak like this also.
I think it's fine for me, ma'am.
Okay,
Yes,
okay,
ma'am. Your
good.
voice is audible. Thank you.
Okay, okay, fine.
Okay, ma'am. Just in 2 minutes, ma'am, we can start.
Okay,
Also, I'm sorry for my camera is not on because my Mac screen has broken today. So
completely.
I'm just using a monitor to connect me. So sorry for that. And also, we are very happy to meet you. Actually, I see a lot of your programs in YouTube and in LinkedIn. I'm really happy to meet to welcome you to our college to present about the IPR. Hope we will have a collaboration.
That's great for me. In fact, I'm going to upload many more. I'm not just getting time, but I'm going to
Yeah,
upload many
just
more videos and on LinkedIn as well as YouTube. Thank you so
sure,
much.
ma'am. Sure, ma'am. Just to inform you, we started working on patents very recently, maybe less than a year, ma'am. So, but our faculties has supported really well through the projects, and so far we have filed 23 patents, ma'am. So far, I think
Okay.
it's less than a year. But in 23, I am sure more than 15 got published, ma'am.
Okay, that's really great.
I
That's
think
really great.
also this is I just want to inform you those all those public all those patents are individual patents, and it's also through some through collaboration with other institutions as well, and some through some support from agencies as well. Now I think we wanted to really go to from individual to as an institute.
Yeah,
So I think
that's perfect.
maybe your support will be helpful to us, ma'am.
Definitely, I'm going to support you in this because at institutional level, this is really required, especially to upgrades to, level up the ranking of the institute in terms of accreditation and in terms of admissions, in terms of commercialization of technology also. So there are multiple benefits involved in this, and that's why I'll definitely advise that as an institute also, as a team, as an institute, you should also file all the resources, all the inventions, all the research works you have with you, either in the form of patents. Maximum it should be in the form of patents, 80-90%. Otherwise it can be in the form of designs, in the form of copyrights, and in various other forms also, that we can guide to each and every faculty, and all everyone as a whole continually, periodically over a period of time of years. And the as our collaboration strengthens up, within some months, I'll be teaching you how, what, why, and how of each and every type of intellectual property rights. But
Sure,
especially
ma'am.
I will start with patents because this is of real importance these days. Even the government fees has been reduced, and I'm going to tell how as an institute we can file patents. This is really
Sure,
required.
sure, ma'am. Maybe with your permission, ma'am. Now it's like 4:32. Maybe with your permission, we can start the session, ma'am. Is
Yeah.
it okay?
Yes, yes.
Okay.
Okay, fine. So I'll be starting this
Ma'am,
session.
ma'am, just a minute, ma'am. Just I will introduce you
Yeah,
so to my faculty. So that would be great. So, sir Srini, sir, shall we start, sir?
Yes, sir. Sure. Thank
Sure,
you.
sir. Okay, so thank you, sir. So, respected our CEO, Dr. R. Manikam, Principal, Dr. R. Muralidharan, our Dean, School of Science, Dr. Suresh, our Dean, Hemalata ma'am, School of Commerce, all department HODs, faculties, and our resource person today, Dr. Prachi Chopra. Good afternoon to all. For joining this webinar on Introduction to IPR, Significance and Registration Procedure. I welcome you all on behalf of Ratnam Arts and Science Research and Development Cell, IPR Cell, and Innovation Cell. I welcome you all. Before starting the session, I would like to give you a short introduction about our speaker today, Dr. Prachi Chopra. I think the ma'am has obtained her BTech from Maharishi Dayanand University in 2012. Ma'am obtained MTech from Ambedkar Institute of Advanced Communication Technologies and Research in 2015, and also received PhD from Indira Gandhi Delhi Technical University for Women in 2020. Especially, I think more than this, more than her education, I think her the work that what she ma'am is doing is really amazing. I think Dr. Prachi Chopra is an IPR expert, IPR trainer. She's a researcher, received PhD, as I mentioned. She's an advisor, mentor, professor. Especially, she's a famous YouTuber. Just to mention, I have seen a couple of videos. It was really impressed the way that she presented and the information that she delivered related to IPR. So that's the reason, one of the reason that I really wanted to connect with the ma'am in order to get benefits, to have a collaboration. We are hoping to have a collaboration and hope so. And also very importantly, she is a founder and so on. So I just actually ma'am's profile is really big, and I just want to stop here just to not to waste more time, and maybe we can hear the details of IPR from the man today. And also behalf of Ratnam College of Arts and Science, I welcome you, ma'am, and thank you so much for accepting our invitation and delivering this great talk to us. Thank you so much, ma'am.
yeah, that's an honor for me, sir. Thank you so much. And today, I hope you get all the sufficient information that you may be expecting from me in terms of IPR, in terms of patents. And please be very, connected, be very interactive. I just want wherever you feel that you have an question and you want answer of that, either you can write in the chat box. At the end of the session, I'll be answering all the questions because I find it really exciting when people are interacting and I'm able to answer all the questions, and in that way you'll be able to get more and more information. This session, in this session, I'll be presenting firstly one presentation. I'll be sharing my slides on the screen just to inform you what exactly is intellectual property right, what are its different types, and what is the registration process. And then I will like to interact with them. I would like to interact with you all actually, for all the question and answers which may be in your mind, and maybe I want to discuss that how we will be working, how we will be working in the next couple of months for your patent filings. And I just hope that all the faculties have joined the session or the
Right,
students have
right.
also.
Actually, today the plan is that almost all the faculties are
Yeah,
here today with us. We
yeah,
didn't invite the students as of, because as we discussed just to have an initiation with the faculties. Then maybe in future we can have a, if necessary, we can connect with the students.
That's completely fine, sir. That's completely fine. So, and that's actually, I think what we have discussed also, that we want faculties only in the very initial sessions. Yeah. So I'll be sharing my slides. Just a minute. So it's, yeah. Can you all please see my screen now?
Yeah, yes, ma'am. Yes, ma'am.
Okay.
We can see
So the
you.
topic for the day is Introduction to Intellectual Property Rights and its significance and the registration process. So the whole outline of the session is we will be discussing that what exactly is intellectual property rights and what are the different types of intellectual property rights, because this is the word which is intellectual property rights, and people, mostly faculties and students know that this is something, but they are not aware even of the definition, what exactly is this. Then we need to understand the definition firstly to go deeper into it. And followed by this, I'll be discussing the importance of intellectual property rights in research and innovation and the registration process, especially of patents, because I would like to start with the patent filings, maximum patent filings, and subsequent publications and subsequent grants, because my aim is to get them granted, published, and then granted. So it's best to first publish, and then we will move onwards. We will discuss that how we can grant it. We will scrutinize. We will discuss the tits and tats where we are lacking in everything. This will be a very interactive and teamwork. So this is the whole outline. Now starting with the first part, which is what is intellectual property rights. See, intellectual property rights refers to actually the creation of mind, whatever you have conceptualized, right? Was it what is conceptualized? Whatever you conceptualize in your mind, it may be an invention, it may be some creativity even. So whatever comes out of your mind as a creative, as an inventive, as an innovative work, that is intellectual property, your intellect's property, and hence intellectual property. This may be some invention, technical invention, R&D invention, that's why it relates to all the universities and institutes, or it may be some artistic or literary work even for other types of intellectual property rights. Now, what are intellectual property rights then? If you have some intellectual property which you have created out of your mind, that has to be protected just like any other property right. If you have some other property, then you give it on rent now, then you own that property. Similarly, whatever you have created out of your intellect, that is your creativity, and you need to get property rights over it. So those rights which are legally given to you by Indian Patent Office, which is a government organization, grants you rights that this is your creativity, this is, you have a monopoly over it, and no one else can use it, make it, sell it, distribute it without your approval, without your consent. And that is the significance, that is the value intellectual property rights gives to you. So what value? Whatever you have created on your own as an R&D, innovative technical work, you hold a right over it through patents, through copyrights, through trademarks, through all these intellectual property rights legally. It's legally, and without your consent, no one can MUSD, make, use, sell, or distribute your invention without your consent. And this is an exclusive right, and you have a complete monopoly over your invention. So I hope I have made it clear what is intellectual property rights. Fine. So coming to the different types of intellectual property rights, okay, we know that we can protect our innovative and creative works, but then what are the different types? What are the different categories under which we can, protect our intellectual property works? And those different categories, the dominant one is patents, followed by other types of also intellectual property rights, which are industrial designs. These are, today in trend known as design patents. Industrial design are these days known as design patents. People are filing design patent also. Why so? Because they are not only lesser expensive, but also they give you value just like patents. So these are design patents, and they protect the structural aspects of whatever creativity you have done. I'll be discussing more on this. And then trademarks, and then copyrights, geographical indications, trade secrets. These are 6 different types of intellectual property rights which are very in use. And there are furthermore also, but in use, the maximum used are these 6, out of which I'll be discussing patents, designs, trademarks, and copyrights, and the definition of these 3. And then I'll dig more deeper into patents. So what are patents? The institute is filing so many patents, and as an individual inventor, you are into filing of patents. What exactly is a patent? Patent is a right. Patent is an exclusive right which is granted to you for your invention. You have done some creativity, maybe in collaboration with your students, final year BTech students, MTech students, maybe some PhD pursuing research scholar has done some kind of creativity for from the last 3 to 4 years, and they have come up with the technical concept. Now that technical solution of to a problem is something which you have done on your own, and you would never want that someone else copies it and uses it for their personal benefits. Obviously what you will want is to protect it on your name, because it is something like a property and you want to have a property right over it. So in this case, the exclusive monopoly of the owner to have the invention in his on his or her name, that is what is called patent. When you go into the hardship of granting of patents, maybe your first file, you'll publish, you'll grant, and then you have the dignity to say that this is my patent certificate, and now I am the owner of this invention. Even I can, outsource it to other companies. Okay, you manufacture it, sell it, and whatever the selling you create, number of sellings you do, you have to give me a royalty for that, maybe 50%, 60%. Why so? Because this is my invention, I have a right over it. You can relate it with the property given on rent. Any other property which is given on rent, obviously you will have a monthly rent over it. Why? Because it's on your name. And similar are the patents. So I'm just relating it so that you are able to understand it. And what is the limited period of this right? This right has a limited period of 20 years, which is big enough, in which a technology almost expires. Technology is running so fast, even in next 5 to 6 to 10 years. Any technology which is right now very latest, it expires in another 5 to 10 years, because we are growing so fast in terms of technology. And hence the government is giving you 20 years a monopoly and property right, and that is more than enough for a technology, for all the benefits you want out of that technology. So this is all about patents. Some of the examples, very 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 well known early years old examples are electric lightning. Now this was something invented by Edison and Swan. Similarly, sewing machine by Ho and Singer, because these are the people who are behind these concepts, who have invented these concepts. iPhone, the owner of iPhone, Apple. So this patent is in the hands of Apple, and no one else can create the same mobile phones as iPhone. So that's why they are the market owners. They have a monopoly in the market as a brand symbol. If brand symbol is like an iPhone, and no one else can create such similar kinds of iPhones, because they have property right, they have patents rights, they have intellectual property rights over it. Similarly, magnetic resonance images, which is a patent, imaging, which is a patent hold by the Madian. So similar are so many inventions out there in the market, so many inventions, robotic inventions, and related to electronics, mechanical, product, process systems. There are so many inventions on which people try to get all the monopoly by having patents filed for them. Coming to copyrights. Now, what exactly are copyrights? See, copyrights is a very different category of intellectual property rights to protect your invention. I'll briefly go through it. See, copyrights protect authors and artists. If you are author of a book, if you are author of a novel, maybe you have written some technical book. I'm trying to relate as per your domain, because you are into academia, you maybe have written some technology book, maybe some research paper, maybe some software coding, maybe some database. So everything which is literary in the sense, or which is artistic, maybe like paintings, sculptures, photographs, architectures, maps, technical drawings, all these types of literary as well as artistic works, these can be protected as copyrights. This is different category. Now here, what exactly is protected? The idea which you have written, the idea which you have created. The same two types may be written by two different people in two different ways, just like research papers. So those are protected as copyrights. Literary works written may whatever you have done, that is protected as copyrights. And the significance of copyrights is that you have a granting monopoly. Property rights are they are active for a period of 50 to 60 years from even the death of the owner. So just like if I talk about music industry, if I talk about film industry, then whatever lyrics are created, songs are created, music compositions are created, these are copyrighted. These are actually copyrighted. And films which are created by the producers and directors, singers, lyricists, they always protect their work as copyright. If you write a research paper, very important for your domain, if you write a research paper, always you have a copyright, because it is in your language, you have written it, you have published it. So what a publisher will do, wherever you submit it in a journal, there is a copyright transfer certificate. You always sign that certificate. If you have published some kind of journal, a publisher of the journal, on acceptance of the paper, asks you to put signatures on a copyright transfer certificate, asking for all the licensing of publication, transferring of your work anywhere where they want. So that is a legal document they are getting signed from you, and they're transferring all the copyright ownership you have in their hands. And this is the way the things are done. Even if you have a book, if you get it published through a publisher, they will always get signed a copyright per transfer certificate. So this is all about copyrights. These are protected. They protect the novels, poems, plays, reference works, newspapers, advertisements, computer programs. Here again, I am talking about your domain. If some of you are from the computer science domain, or you into some core in-depth coding, whatever coding, line by line coding part, mathematic बिल्कुल the computer coding part which you have written line by line, step by step algorithms, all that is protected as copyrights. However, whatever the coding, when the coding is dumped into the hardware, the technology behind that hardware, how the technology works in the form of hardware system, in the form of technical concepts, procedures, methods, that is protected as patents. And line by line, just the coding, if it is only coding without any real significance, without any purpose, without any functionality, that can be protected only as copyrights. But if there is a technological concept that can be of use for the industry, that is novel, that is original, that is protected as patent. So this is the main confusion which occurs, that how can we protect our codes, through copyrights or through patents, right? So similarly, next, these are the all day everyday copyrights, like literary works, musical works, artistic works, dramatic works, and recordings. Coming to the next, which is industrial designs. These are of very much significance these days, usually known as design patents. Now what they protect is, they protect the ornamental or aesthetic aspects of the article. Making it very simple for you to understand, they protect the appearance of any product to your eyes, the shape, the surface of the article, the two-dimensional lines, patterns, or colors, or three-dimensional shape, structure, surface, how it looks like to the eye. Suppose I have invented a robot. So in that robot, there are three things I want to say. I'm just giving you an example. Please be with me. Please listen to me. I'm giving you an example of robot. Now suppose in this robot, how it looks like. Where are its hands? Where are its lags? Where is the wheel? Is there any wheel? How it looks like in the from the front, from the side, from the back, from the top, from the bottom, how it looks like. That appearance of the robot is actually protected by design patents, industrial designs. The appearance to our eyes, how it looks like, the ornamental aesthetic aspects, these are protected by designs. The technology by which it is working, the robot is working with some technology, maybe there is some machine learning algorithm, maybe some deep learning algorithm, some artificial intelligence behind it, some maybe anything, or maybe any other technology, like any other technology, some financial work related to blockchain or any other technology which is there. So that technology, how it is working, how it takes the input, how it gives the output, where is the controller, where is the microcontroller, where is the processing unit, any other processing unit, how the inputs are taken up and processed and then stepped where and then stepped where, and then how they are giving to output, how it realizes what function it has to perform. That is protected by patents. That technology is protected by patents. So how it looks, protected by design patents. How it works is protected by utility patents, normal patents which people are filing. And then if there is some coding, backend coding which is dumped, obviously it has been dumped into the robot, and where is some microprocessing algorithms which are working at the backend, those exact line by line algorithms are protected by copyrights. So I have in one example given you all the three types of intellectual property rights, that what exactly they are protecting individually. So this is the real significance, that which type of intellectual property right can protect what kind of thing. This is of real value because people come to us for such kind of advice. They want to know that, so ma'am, we have this product, where to protect it, through design patent, through utility patent, or through copyright, through trademark, where to protect it. They are not even aware of this thing. So I am telling you so that your mind is better prepared about all these things. Similarly, and if you want to file a industrial design for the structural aspects, it protects for the duration of 10 years, and it can be extended up to 15 years. So protection is for 15 years for design law, for design protection. So some of the designs like this, Apple iPhone, the user interface of Apple iPhone, the side view, the back view, and maybe if there is a game, someone has created some game, maybe in your college someone may be working on a game, how to create a game, so how that game will be looking like. So just like the fourth image on the first row, that is protected by industrial designs, design patents. And then the goggles, maybe the shape of the goggle, if some fashion designer has created a dressing piece, so that piece of dress is actually protected as design because it's a design. Maybe Sabyasachi has created a new dress piece, that has to be protected as industrial design. Printer's shape. So any other structure is protected as industrial designs. I hope I have made it clear. Next, I come to the last intellectual property rights, which may be of significance in academia in your institute, and that is trademark. I have heard so many institutes are now creating incubation centers. They are starting up with new startups, new businesses, so that entrepreneurs come out of their institute. And this is actually, fostered by government, that all the institutes should be working on incubation centers, provide proper support to their students for become as an entrepreneurs. Yeah. So in this, trademarks play a real significance. What do trademarks protect? The brand of any startup, brand of any company, brand of any incubated business. And what they protect? The logo, the name, the numerals, the tagline, the tag sound, whatever creates a brand value and maybe of significance after that business flourishes in the next 10 or 12 years. So all these things which are distinctive signs that identify certain goods and services produced or provided by a company or an individual, those are protected by trademarks. When I'll give you some examples, this will be very clear to you. And these are protected for a period of 10 years, and they can be renewed to make it lifetime protection. Every 10 years you have to just renew it, and it becomes a lifetime protection. This is of importance for incubation centers. That's why I'm saying, because corporates obviously ask us to file trademarks. When I talk to research institutes or university people, then this is of real importance for them in terms of incubation centers. To give you some examples, like Apple name, Google name, Microsoft, Infosys, Tata, all these names. Can any other new startup use, state their business with the name Tata? No, it cannot be done. It is legally not allowed. Tata can sue you because they have a trademark filed in the name of their word, which is TATA, Tata. Similarly, Apple has a big, prominent logo of an eaten apple just on the second image of first row. So this is a trademark filed by Apple. No one else can use this logo. Nike with a check sign is a trademark filed by Nike. Infosys with the tagline "Navigate your next" is something, a tagline used by Infosys. People know Infosys because of this tagline. And Coca-Cola, the shape of the bottle of Coca-Cola. Can any other cold drink manufacturer can use this bottle? No, they are not allowed. It's a trademark filed by Coca-Cola. Any other, chocolate shapes are also protected by trademarks. Like Kit Kat has a special shape. Toblerone chocolate on the screen has a special shape. It is protected by these manufacturing owners. And maybe some Milky Bar, I think, has a different shape. Similarly, there are so many chocolates coming into the market. They have different shape, and no one can copy each other's shape because kids do not remember the name. They remember the shapes. They ask their parents to buy that type of a chocolate which is having that kind of shape. Sometimes it happens. So it creates a brand value for them. So I always give an example of a tag sound, which is ting ting ding, the taste of India. So these types of taglines, they are known because, and when you say them, people are able to recognize the name. If I talk about Amul butter, it has a small pony doll, and it is on each and every Amul butter. I hope it's in the south, I don't know, but we eat a lot in north. So these types of all the things which are people are able to recall because of maybe some word or logo or tagline or tag sound are protected by trademarks. So I have covered what is intellectual property rights, what are the different types of intellectual property rights. Coming to the third and single slide of importance of intellectual property rights in research and innovation, I want to discuss why to file an IP. Why should we file patents? Why patents? Why copyrights? Why trademarks? It creates a commercial value. I'm talking in aspect of business values right now, and then I'll be discussing about the academic values as also. It gives you protection. Whatever you have created, you can protect it with all the monopoly in your hands. So the word is protection. The first thing it provides is legal protection to forbid all others from using your invention without your consent. So this is how you become IP right holder, patent right holder, copyright right holder, trademark right holder, or design right holder. Okay. Second is commercialization. Even though you are in academia, you can commercialize your work which has been patented in your name to other manufacturers and then get royalties from it. It helps in commercialization. It helps in facilitating in the process of innovative technology in the market. You can create technology based businesses. What was iPhone was just a technology, and Apple created a business out of it. So it helps in creating a business by just a single product being protected as patent. And then you can create a business. Why? Because you can sell it for another 20 years, for the years it is active, and get so much commercial benefits. You can monetize it. Third is enhancing competitiveness. If your institute files, suppose I say next 50 patents are filed in the next year, Won't it create a competitiveness feeling in the neighboring institutes? They will be thinking, oh wow, this institute has been running so fast in terms of research and innovation, and so they will be motivated to do some filings and create, enhance the value of the institute in terms of R&D, because this is of real importance these days in terms of admissions and accreditation ranking and all. So it enhances competitiveness, it creates your brand, it creates your value, it creates your dignity in the society. And also licensing. If you are into academia, you have a specific profession and you love it, but then if you have done some kind of an innovation side by side, you can earn out of it by, obviously, I think I have discussed this, you can outsource it to some manufacturers and you can have a partnership with them that 50% will be mine, 50% will be yours of whatever amount the any product is sold. And for multiple products this can be done. Why so? Because the product is in your name, they will be willing to give you 50% and they have not invested in R&D, they are just manufacturing and selling it. This is of real importance. This is of why people, as industries filing so many patents these days. There are so many industries which are day by day filing patents, day by filing design patents, day by day filing copyrights, trademarks. And that's why government has even now reduced fees and saying they are motivating even the institutes to file more and more patents, so then more and more entrepreneurs, more and more R&D labs, more and more innovation comes out, and our society, our economy as a whole grows. And they want to look which all institutes and universities are helping filing more and more patents and growing as an R&D dosed institutes, so that more and more admissions are taking place. Next, now I have discussed everything about intellectual property rights as a whole. Now I'll be limiting my discussion. I hope you all are with me. I'll be limiting my discussion to only patents, because this will be focused especially on how patents can be registered. You all, as I have been informed, have filed 23 patents on your own. I am going to discuss how the procedures go on, what are the steps that are being carried out, so that if you are not informed, even for the existing patents which are being filed by you, you should be aware of where you are lacking. You must know what exactly is the next step, or which step you may not have done, maybe missed out, which we are not aware of. So that's why I'm telling what exactly are patents and how we register them. So patents, as I've already informed, these are exclusive rights which are granted to exclude others from making, using, selling, or distributing your invention. Which, if you have a creative thing, you have invented some technology, you know, you can give each and every detail in terms of drawings, in terms of technology, in terms of step by step framework, system design, that how you have gone through to create this product, create this system, create this process, then you can patent it if you are aware of everything. And this is something which is conceptualized in mind. Sometimes, I get a query, I have not prototyped my invention, can I file it as a patent? See, obviously I will prefer that you should have a prototype, but still, if you are working on it, you have still not done it, or it is not feasible for you to do it, maybe because of the costings involved, it's a big funded project, you cannot do it, but then you can always file a patent over it. What I've seen is, when people file patent over it, if you are very clear how it will be working, and if you're not clear, then there is a separate way of filing, a different type of filing. If you are very clear that how it goes on, you can file a complete patent application. If you're not clear, there is a way of filing provisional patent application. Now patent is filed, this gives you a status called patent pending status, and it helps you get so many sponsored projects from the government. Even the government gives you funds for lakhs and lakhs, maybe 30-40 lakhs. I've seen people like that. They give you, when you file patent and say that we have a filed patent on this, we are so sure that we want it to be granted and published, then government easily gives you lakhs and lakhs of grant to implement that project even. So this is, if you can get so many projects in your institute by just getting a patent pending status and then filing for a research proposal in front of the government. And so, coming to the patent types of the works which are patentable. which all works can be patented. It can be a process. This I think everyone is aware of. If there may be some biotechnology section also here. Are you all having biotechnology section also?
Yes, ma'am. Yes, ma'am.
Okay,
We
okay.
have biotechnology.
So there may be there are students and faculties from engineering side, from biotechnology and pharma side. So from different sides there are, this is a mixture of evergreen and different diversified technologies. So any process of pharma or engineering, maybe some chemical compound, the procedure behind producing that compound composition, that different elements, how they are combined together, any machinery, and any article of manufacture. By article of manufacture I say, if there is some computer science student or faculty, they may have created some program, may have written some program, and that can be dumped into some hardware, or in the other way around, it can be you can write it on a CD, and then wherever you put that hardware functions like whatever your programming is. So that kind of article which can be manufactured, and any other composition of matter, all these types of works can be patented. Means any technical work, the system, the method, or a product associated with it, to be very simplified. Any product, any system, any method, any procedure can be patented, which should have some technology behind it. Now, what is the eligibility for patentability? Very important slide, very important. What is the criteria of patentability? What government checks? Examiner, when your patent is submitted to an examiner, what he checks? He checks if your invention is novel and it is non-obvious and it has some industrial applicability. First three criteria are checked very comprehensively. What I mean by novelty is, now this checking is done globally, not in India. If you are submitting in Indian patent office, they will check globally that if an invention just like yours has been filed as a patent before you by anyone globally from the from the patent database, which is publicly available. You can also do your novelty search from Google. Google Patents is a website. You can go there, you can search if whatever is your conceptualized framework, is it already done by someone, is it already filed by someone. If it is a complete duplicate copy of the same invention which has already been done by anyone else already in the previous dates, then it is not novel, obviously not novel. And this is the criteria for research papers also. Similarly, non-obvious means it should have some kind of inventive step. It should not be like the two or three prior filed patents can be combined together and they are same as whatever you have done. You cannot just make a combination of two or three patents and say that this is my work. It should have some kind of synergic effect. Synergic effect, by that I means it should be providing some functionality just because of the cumulative effect of two or three things, maybe if they are filed by anyone else. But then it should have not just, it should maybe if you have mixed something, it should not be heterogeneous mixture. It should be something which is homogeneous and giving some synergic effect because of the mixing. So, and it should not be just the mixture of two or three prior art works and you are saying that you have filed as a patent. Not just addition of features, not just addition of works. Similarly, industrial applicability. It should have some industrial use. If you have done something which is of no use for the norm society, which cannot be sold as a product because it is of benefit to someone, which is of no use for the industry, but in fact it is worse for the industry. Maybe you have created some destructive weapons and all that stuff. So those types of works cannot be patented. And for one more thing I want to say is there is some criteria laid out by Indian Patent Office, which is section 3 and 4 of Indian Patent Act. We can discuss on this if required, but obviously when we are getting some inventions, we scrutinize them that they are not coming under those sections. There are some exceptions which cannot be patented, like software codes only, without any technology benefits. Just software coding, one by step coding, without any technical dumping into hardware or technical utility. They cannot be patented, they can be copyrighted. Similarly, literary works and artistic works, paintings, sculptures, architectures, they cannot be patented. They can be protected as copyrights. So there is a different set of types of intellectual property rights which protect different things. So for patentability, if you have done technical work, then I have worked with so many institutes and universities. Most often their works are eligible for the patentability criteria. Now, also what we do is we provide a form which is invention disclosure form, and we ask all the faculties to fill that form and then provide their inventions. So what the main aim is that invention should be provided to us in the most detailed manner, because what the government says is that whatever description you are providing about your work, it should be very clear, it should be very complete. This is a kind of give and take relationship which government says that if your work is not properly written, that a third person, when he or she reads it, he must be able to implement it on their own. If they are able to implement, then they will get it published and give you all the rights. But if a third party, when he reads your draft of patent, they are not able to themselves do it, implement it, then there is no use, and then there may be chances of not getting a grant over it. So this is also one of the criterias, that any person who is having ordinary skill in your technical area should be, it should be very clear and complete to that person. And he should be able to engineer it. He should be able to implement it by reading your patent application. And but then you should not be afraid of it, because you are getting legal right over it. They cannot misuse it, because this is your invention. Because you have legal rights, you can stop them from even misusing it. So this is the significance of patents. Now coming to some mistakes done by inventors. When should a patent be filed? A very big question, very big confusion. When we have created it in our mind, or when we have prototyped it, or what, or when we have tested it, what is the right stage to file the patent? See, the right stage is when you are very clear that how all these steps are linked to each other, what is the specification, and how exactly will be the technical drawing of it. Maybe or may not be you have prototyped, but that is the right stage. And if you are not even clear, then you can file a provisional patent application. There are two types of patent application, which is one is provisional, one is complete. When you are clear with all the concepts, then you file a complete patent application. If you are not still clear, and you say maybe in the next coming 1 year I may come up with a few more inclusions in this invention, I may include this, I may work on this, I'm still working on this, then the best is to file provisional patent application. Why so? Because why people are so eager to file it so early? Why don't you wait for the whole prototyping of the work? The point is that earlier you file, you secure an earlier filing date. Maybe while you are working, some other works on the same invention and files on their name. Then it will be taken up as a prior art for your work. And maybe it may hamper the novelty of your work. That's why people take an early filing date, so that when an invention, sometimes even in year the invention becomes obsolete. All in terms of COVID, there were so many filings being done single day related to COVID. Now why were people not waiting? Because, but they still were under clinical trials and people were working for it, but patent was filed in the very early stage. In terms of Covishield and any other vaccine, which Pfizer and all, their patents have been granted, but still clinical trials are going on, even when they were not commercialized, even when they were not into marketing, into the market, their patents were filed. Why so? So that their competitors don't file before them. They were so scared of this fact, because otherwise their work will become a prior art, and this will uh, make their work not novel. So they didn't want anyone else to just copy it and file before them. So this is the main agenda of getting an early filing date when you are still working on it. And can an invention, okay, this I want to discuss with all the inventors out there, because all the academia people are into so much research publications. Can an inventor, can an invention be patented after publication, maybe in the journal or displaying the public exhibition? Which is, the answer is no. Please listen to me, that when you publish your research work, maybe in the journal or research paper, if you get published in the journal, as per my B statement, in the very certain, very few circumstances, in very rare chances, government gives you a grace period of 12 months to file a patent on the same type of work which you have published in a journal. But the best advice I will give you is, when you have done some research work, first file a patent over it and then submit in some journal. Because when you file it in, when you submit it in some journal for publication, you can show that this is a patent we have on this research work. And because the author name will be same, it will not be treated as a plagiarism content, it will be not treated as a prior art, because it is on your own name. But what happens when you publish it first and patent afterwards? Government may check that the publication was on your own name, but because it was into public, they treat even that research work as a prior art, hampering the grantability of your patent. They don't consider that it doesn't add into plagiarism or anything like that, it is on the same inventor's name, so same author's name. They don't consider all these facts. But a research paper journal publisher will consider this, that plagiarism cannot be included in this case, because this is a reference, you can enter in the reference that this is the work which is done on our own name. So that's why I always say that, patent, file a patent first and then get, uh, put it into some journal, for a review and for publication. This is of real importance. Who and how can a patent application be filed? Who can file? Any inventor, any assignee of the inventor. If you can provide rights to any other inventor, although you have invented, you give rights to your students, maybe you give rights to your institute, maybe you give rights to any other colleague, maybe, so that person can also file. And then legal representative of a deceased person, maybe if you have invented some, and then maybe it's a case that the person has deceased or expired, in that case a legal representative of that person can also file the patent. And then how can we file? Either provisional or complete patent application, as I have discussed. When you are ready with the work, file complete patent application. When you are not ready with the work and you are still working on it, to secure the date, file the provisional patent application. In both the cases, the fees is 1600, government fees is 1600 only if you file in your name or educational institution's name. Now, earlier it was 8,000 for educational institutions, now it has been reduced to 1600. And if you provide fees for provisional patent application, wherein you have to file complete patent application within 1 year. If you are not ready with the work and you file provisional patent application, you have to file the complete application within 12 months. Otherwise, your patent application gets abandoned. This is the criteria, that you have to file it within 1 year, sorry, within 1 year, within 12 months. And there is no fees for this, that. Government fees will be zero because you have already paid the government fees at the point of provisional patent filing. So the government fees is only given once, but there is a foundation that you have to file the complete patent application within 12 months. Otherwise, whatever you have filed, that will be abandoned. Or the other way around is that you have to just file complete patent application and then it will be published and examined. Next is patent publication. When you file the patent application, it gets published after the expiry of 18 months. When 18 months from the filing date are complete, then your patent will be published. Now there is a one more thing I want to say here. As you have filed many patent applications and you were saying that these and that many patent applications have been published, if the government considers that your work is good enough for the defense purpose, this is for the very rare cases, and if someone has done work related to military and all, then they may consider the work not to be published because it is related to government, related to the secrecy and defense purposes of the government, and they don't find it wise enough to publish. So those are rare cases. We don't file those kind of applications. We generally advise the people who are working with us that this is the kind of a work which will not be published by the government. It may come under those considerations, so please don't file. So we beforehand advise is for such kind of works. And third, I want to say that some people come to me and some inventors and say we don't want to work for wait for another 18 months. We want that our application should be published within 1 month itself. So government has a special provision for that. Government says, Indian Patent Office says, if you want your patent to be published within 1 month, you can do that by filing a form 9. We know that all those forms, we can discuss that. But then there is a government fees associated with that form of 2500, which is early publication form. And if you file that along with your patent filing, then it can help you publish your patent application within a month and not on expiry of 18 months. So this is a special privilege which comes with the prescribed fees, which is totally government fees. Now, when and how are patent applications examined? Till now, as I'm able to understand, you have published all the patent applications. Now, there is a special way of getting it granted also. Now, what the government says is, the government says that patent applications are not examined automatically in India. You cannot say that if you have filed a patent application, it will be published and it will be examined also. No, to get it examined and subsequently get it granted or not granted, which is totally a decision done by the government. And there are chances that it's not like every patent application which is filed will be granted. The best ones are granted. And so to get it examined, you need to file a special form, which is form number 18 or 18A, followed by a prescribed government fees by your legal representative. And then examination, when you file that examination request, then the government reverts back to you for your patent application which has been filed by you within 1 or 2 to 3 years. Sometimes I have seen it comes back in 3 years, and it provides you all the objections. Even for the top class best works from the reputed government organizations, get the objections. So your work is good or bad, it will always be followed by objections. You will always get the objections, just like major and minor reviews in case of research papers, if you are able to relate with that. Major changes, minor changes. So similar is the case with the patents. You will always get the objection report. What you have to do is you have to, within 6 months from receiving that objection report, revert back to government with the response, stage by stage comprehensive report of response of 20 to 30 pages, stating that how you have amended, either amended or defended whatever you have written. Either you have to say no, we are correct, or you have to amend it as per the objections laid out by the government. So that strategy which should be followed, that we take the charge of, that how we have to do it to take it up to the grant level. Sometimes we see that 90% objections are so so in this way, we do this. I think someone has unmuted the mic. Please mute, ma'am. Yeah. Okay, so this is the way of getting it examined. Now the point is, there is a way of getting examination within a year also. There are special criterias for that. The government fees is also different for that. But then in those cases, the examination report is received within 6 months or 1 year. So what we can do is we can expedite the process if we want to do it very early. But that is always followed with the government prescribed government fees. And one more thing I would like to add on here is, when you have filed your patent application, you can get it proceeded for examination anytime between 4 years from the filing date. So if you have filed in 2019, you have got it published in 2020, then you have a privilege to get it examined anytime before 2023. You have 4 years of time. If you don't file the examination request within these 4 years, then you lose that chance. Now that patent application cannot be processed further for grant if at all you require. So this is the way. Then procedure followed. I think I have explained this process. I have already explained it, that you receive the first examination request and then you have to revert back to the government with the first examination response to that request. And then the government will read that response. It will either grant, please be with me here. When they read the response, they will either grant the patent, or they will say that we are not convinced, please, just we want to have a hearing with your attorney, with your lawyer. So there may be a hearing as well with the lawyer. So government notifies you, gives you a time period, you have to acknowledge back. Yeah, you have to acknowledge back that you will be there, attended, you will attend the hearing. There will be a face-to-face session with the government personals, controller and examiner at the Indian Patent Office. And this may be online or offline, like in the COVID scenarios these days, always the hearings are online. It's like a court case, we file, get the draft, we get the objections, we respond it, we may be having hearing, and then it is finally up to the discretion of government. Government decides it will be granted or not. But we have worked with so many institutes and corporates and startups and global network, global offices. We are able to understand that what exactly is the direction in which the case is going, and we are able to realize that is it going to be granted or not. And in this way we help you, assist you to scrutinize those applications, that these should be forwarded for further granting, and these can be left up to publication. Because after granting you get a certificate and you have a right over it now, and after publication it will be in the journals of the Indian Patent Office. We provide you the PDF files of those journals in which it is published, just like any other research paper. So it's a patent journal in which it is published. So this is the significance of publication and granting. Then we come to patent renewal. Now this is not of much importance, but I must inform you, the after grant of patent, it has to be renewed after every 3 years to make it active, to keep it active for 20 years of its active period. The renewal is followed by a very nominal government fees of thousands and 2000s every year, and it's not a costly fees, but then you have to get it renewed so that Indian Patent Office knows every year you are renewing it. They knows that you are active with your patent and you are getting benefits from it. So that it's up to you, you do this or not. But then this is a special way of patent renewals. This is the patent cycle which we have discussed. First, we do the patent filing, provisional or complete. Then we have patent publication. Then it is examined. When you file the examination request, you get a first examination report from the government, and then you file the response of that first examination report. Then there will be or may not be a hearing, which is decided by the government, Indian Patent Office. You want or not? Indian Patent Office wants or not. Hearing, after hearing, it is decided that it will be granted and or not granted. Then the renewal, and then after 20 years it gets expired. This whole process takes almost 1 to 2 to 3 years for granting, and expiry is after 20 years, and publication happens after 18 months, or it may happen after 1 month if you pay early publication fee, if you request government for early publication. Now, so this is all about my PPT. I hope I have made it very clear to all that what is intellectual property rights, what are the different types of intellectual property rights, what is its significance, and how we file patents, how we get them examined, how we publish them. I have explained everything on at my end, and I want you to, if you all have any other question, you can ask me and I'll be answering on those questions. Over to you, sir.
Thank you so much, ma'am, for uh, for a deeper understanding about IPR. I think definitely it helped us even since we are dealing with patents. I also got some new information from you related, like whether we can publish the patent before our article publications or not, and what we can publish. These informations are hidden, so we are always whenever we would like to try to patent, we always have a problem with what information or what things we can patent. So this information is very clear, because I also sorry to inform you the departments that we have here. We have like science departments, ma'am, and also we have commerce, we have management. So it's like group of departments together. I think I would ask like couple of questions to you, ma'am. One thing is that I think you have mentioned about the patenting related to research work. Coming to commerce department or management department, how they can contribute to patent in their research work.
Okay,
Uh,
okay.
yeah.
Yeah, I have got some those kinds of requests also during my this entrepreneur journey, that people from management also want patents, but then their work is not related to technology at all.
Yeah.
So regarding that, I want to discuss that how they can get their works patent. The best way for them to get the work patented is, suppose they are doing work in case of in maybe some entrepreneur resource planning, maybe related to CRM they are working on. These are some of the concepts, acronyms which I'm talking about management, that enterprise resource planning, CRM. So if these are some of the frameworks or any other management framework on which business work, which on which they are working on, they have to integrate it with technology. Maybe like maybe some financial business model they have created, they have to integrate it with blockchain, which is related to finances. They have to integrate it some advanced technologies like machine learning. Or the point is, okay, if I say there are some e-commerce platforms, business models which are working online. So yeah, so what they do is they keep on upgrading their websites of business. How? By in maybe they must have done something which makes it easier for the people to do payments when they are doing online shopping. I'm just giving you an example of a business model maybe related to management. whatever their business model is, they have to integrate it with some technology. Otherwise, it's very difficult for them to get a patent. I have got some patents published for management people also. What we have done is we have integrated CRM with artificial intelligence to optimize the CRM.
Okay.
Customer relationship management system has been optimized by introducing machine learning and making it automated. So we have
Okay.
automated it. So technology has been integrated with CRM. Similarly, ERP, we have done this by integrating it with advanced algorithms, and we have used blockchain also to integrate it with some management works. And so when we introduce technology into management frameworks, it becomes patentable. Other way, if it is simply a business model or a business framework, that can only be copyrighted as business models. The only way is to get it copyrighted. So if through some way you can integrate it with technology, make it automated, make it online visible and online, uh, internet marketing based, where it always requires technology, you can get it patented. Yeah.
Appreciate it, ma'am. I think it's clear about that. Also, we have a department on fashion, ma'am. I also hear from the department that they have many designs.
Hmm.
The students, as for their project, I guess they are doing designs. I think, as you mentioned, that these designs can be also, if they want to patent as a design, do I just want to know those designs should have any content, or how we have to uh, yeah, make those designs into a patent. But I'm sure they are trying to do something. When I see them, it's really different. I don't see from anywhere else. But how can these designs can be patent? Is there anything that we need to address about that patent?
Yeah, so these are, known in India as industrial designs, and they are, very well known by everyone as design patents, because these are also known as design patents. Usually, academicians and universities and institutes are filing so many design patents. Why so? Because a utility patent, normal technical patent, which is of more value than this, it takes 3 to 4 years to get a grant over it. But design patents, you can get a grant certificate, hard copy of grant certificate within a year. It takes an year to get a grant over it. The procedures are very fast. One number is this. Second is it is cost effective. It has lesser costs. So these are the two major benefits in terms of decision makers. Why to have a few of the design patents also, because it gives you grant certificates quite earlier than the normal utility patent certificates. But the issue is technical, or also called utility patents, they protect the technology, which is actually what you have done in the R&D 3 to 4 years. The design patents protect the structure. They protect what it looks like. So it doesn't protect the functionality. You are not able to protect how the function is done. If you want to protect the function, you have to go through utility patents, also known as technical patents. I am repeating it so that you are not confused between utility patents and technical patents.
Yeah, yes.
That it protects the functionality, but the design patents, they protect only how it looks like, because structural aspects sometimes create a very good commercial ability. They are, because if you have an Apple iPhone, there is a functionality which has been protected by Apple through utility patents, and the structure of the user interface, the icons, the shape of the phone, that is protected by design patents by Apple. So if you have some departments which are working on product designing, they have a special design with them. They have a special structure shape which they want to protect, that can be done, especially in terms of I want to say about mechanical engineering students, fashion designing department, if it is there, the dress pieces they have created,
Yeah.
anything they have done on their own, creative works of art, literature, cultural, all these things. I think in Rathinam, there is so much of creativity being done, as far as I know, in terms
Yeah,
of designing. There is so much contribution in designing, and this design patent is going to be of real importance for you. And I must say, copyrights also, because
okay.
these two things, copyrights and design patents, they protect the artistic works, they protect the fashion designing works, they protect the product designing works, all the structural shape, features, pattern, designs, lines, and whatever is of value to the eye of a person. And maybe if some people are into novel writing, poem writing, literary works, if there is such kind of a department also, that can be protected as
We have
copyrights.
we have English department. They also contribute on writing.
Yeah.
Also, we have Viscom, visual communication. They
Okay.
also contribute in designing, like taking videos, like photographs.
Videos. Yeah. Video, literary work, artistic work, musical work, sound recording work, broadcasting work, filmmaking work, any such kind of work. Copyrights is of real importance for you all.
This is
Should you,
something.
you
This
know,
is something that new to us. Also,
yeah.
I think I think the HODs are hearing. So I think
Yes.
we will be really thinking about how to contribute.
Definitely, sir. And it is, you can get it in a year or so, within 1 or 1.5 year. It doesn't take that much time as required by technology patents, and it's a little cost effective than also, because patents are little costlier and copyrights are little lesser costly, and even the industrial design patents are a little lesser costlier, and they are also can be, we can get the certificate, hard copy of certificates, if they are novel and original, even 1 or maximum of 1.5 years. And they protect these types of creativity which you feel that they cannot be protected because they don't have technology involved in this. So it's not like they cannot be protected, you can always get it protected. We need to be aware that what are the different types of intellectual property rights to protect it. So I think through this webinar you have got to know that these can be protected as copyrights or industrial
Exactly,
designs.
exactly, ma'am. Exactly, ma'am. Ma'am,
Yeah.
as I am involving in research and development, you mentioned about the grant.
Yeah.
That maybe at the initial stage of our work, if we are interested into patent them, and if we don't have financial support, I think you mentioned there is some schemes that we can apply for from the government in order to finish this work. So, can you share about this part, ma'am?
I'm not able to relate to what exact slide you
You
are talking about.
you were mentioning about the grant support from the government in order to complete the patent work. Maybe you said financially. If we, I
Yeah.
have an idea. If I have an idea, I know what I can able to do it, but I don't have enough fund to proceed to a
Yeah.
prototype.
Yeah, so the point is there is a special trend that so many, it's such a big line and people are fighting for research grants and sponsored projects. They want to get, funds from the government for implementation of the work.
Yeah,
Now, it's not a foundation. You have to complete a work and then file a patent. The
yeah.
point is, if you are working on it, you have conceptualized it in the mind, and there are ways to get file either provisional patent application or complete patent application and be still working on that. And even in fact you can file complete patent application if you have not yet implemented it, but you are very clear in mind that this is how this will be working, and you are able to provide in-depth details of the working in terms of specifications and all. You can file the patent. How it helps in terms of financial granting is, when you have a patent pending status, which is a status given to you through patent filing, obviously it will be online, everyone will be able to see that this type of concept has been filed by this and that person. It's online that the patent has been or filed, it will be subsequently going to get published. Now if you go for with a research proposal to any of the government DST projects or sponsored or funded projects,
Okay.
there are maximum chances of getting it funded by you, getting the research approved proposal approved, because it creates a very positive image in the minds of the people who are examining your research proposal, that the
Okay.
person has even applied for a patent application. So it
Okay.
becomes far easier for you to get a grant over of that research proposal. That's what I was trying to
Okay.
inform you. Yeah.
Yeah, so I think one good thing that we learn from is that okay, if we have filed any patent, that is going to help us to get the grant. Uh,
Research grants and sponsored
yeah,
projects are very easier for you to extract. Government always checks, have you filed a patent on this idea or not?
yeah, okay, ma'am, okay, ma'am. And also, ma'am, to just mention to you, we as our group of Ratnam group of institution, we also have AIC Rise. You were mentioning about the incubation.
Yeah.
We are funded by Niti Aayog. So we also have an incubation center. We also encourage startups. So just want to inform you that we also have such an
Okay.
incubation center
That's great. That's great.
focusing on sustainable development. So that's ma'am. Another thing, ma'am. Last question from my side. I don't mind. Maybe we can ask from other participants. I just want to ask you: do we really want an IPR expert in order to grant the patent successfully? Because as of now, I am a researcher. We try to file the patent. How important and what is the specialty in order to collaborate with an expert like you in order to get succeed in granting? Is it really maybe please don't take it seriously. Is it really we need such an expert to be with us, or is it okay that, or what is the advantage and what is the disadvantage without the expert like you or with the expert with you like you?
So the point is that what is filed in front of a patent office is not a technical patent application. It's a techno legal patent application.
Okay, okay.
Yeah, this is the
That's
main
how
what I want to say.
I think I
And
also
yeah,
maybe, yeah, I agree with you because technical, okay,
you can write a
but
research paper. You can write a
legal,
research paper.
it's I think even the writing is different. That I agree with you.
Even the writing is different. I am going to say so many points on this because I was earlier into research, and when we started our company, we are into this for so many years, and I have been personally into this before I started my company, and it's been almost 10-12 years now. It's a gradual process, which is a learning which takes years and years of experience. And as an inventor, we are not aware of the facts. When I'll provide you drafts of the patent application, you will be able to see the difference, that what kind of patents are granted and what are not granted. If
Okay.
a person as an inventor files patent on their own language with their own concepts, they are not able to get a grant, and this is something I can say with 100% surety. The point is, you are not aware even of the 1% what legal aspects are to be incorporated, and the government checks for the legal aspects, that how the patent application includes those legalities, and maybe you are not able to check that what exactly legal things have been included. Secondly, we know how to introduce the technology in what pattern, means
Okay.
there is a special layout. And in terms of Indian Patent Act, which is a booklet, you need to learn that. Oh, all in all, in summary, I will say it takes a learning which may take almost 6 to 7 years, which
Okay.
we
I
have.
understand.
Yeah, obviously why people outsource is because they are not learned, they don't know the procedures, they don't know how they have to interact with the government. We know the tactics, we
Okay.
know how we have to create the response of the objections. We have some special internal links also, I must say here. And
Okay.
we that is actually required sometimes. We know how to do hearing in front of the examiner. Examiner always doesn't even entertain the inventors. They always say, where is your legal attorney? Because they feel comfortable talking with the legal attorney because they are able to reciprocate with them. They are able to understand each other's language because they are into the same profession for so many years. So
Yeah.
if they do say something as an inventor, you will not understand what they are saying. As an
Oh,
inventor, you will not even understand what they are saying. And as an attorney, we will understand it because it's a profession, it's a techno-legal profession which we are into from so many years, an examiner, and we as your attorney also. So that's a professional talk, which is very different from a technical talk. I hope I am able to make it very clear to you.
yeah, yeah, yes, ma'am, exactly.
See,
So I think,
obviously, just to give you a small example, if a mechanical engineering student explain his or her invention to a person who is from very different department, maybe a lawyer, so
yeah,
mechanical engineering student can never explain their technology to a lawyer who doesn't know even what is barrel, what is turret. I mean, he's not aware of any mechanical wordings, mechanical concepts, and so you will not be able to relate it. So
uh, good,
that's the
ma'am. Good, ma'am.
difference.
Thanks for explaining this. Also, ma'am, if I have a contribution collaborated with another country, say for example, I collaborate with different countries in research. If we are able to bring a prototype, is it easy for us to make a patent?
Just a minute, sir. Just can you please wait for 2 minutes? Just a minute.
Sure, sure.
Just a minute, sir. I'm coming.
Meanwhile, the participants, please fill up the feedback form that has been posted on the chat box.
Also, maybe if you have any questions, I think it would be nice to interact with the expert regarding any IPR. Nice. ஏன்டா விடுங்க நாங்க போனீங்கன்னா வாங்க எனக்காக வாங்க ஓகே
Yeah, I am sorry, sir. I was actually.
Not at all a problem, ma'am. It's fine, ma'am. It's fine, ma'am.
Yeah.
Actually, ma'am, I think I'm just to open the session to some faculties. I think there is Dr. Velumani from Computer Science. I think he would like to interact with you. Yes,
Okay.
sir. Please, sir. Velumani, sir. I, Kanagaraj, sir, maybe you can interact. Maybe we will give you the
Sure, sir.
chance to.
Sure, sir. Good evening, ma'am.
Good evening, sir.
It's an interesting session. So we have learned a lot of things.
Kanagaraj sir, just a minute. I think Dr. Kanagaraj is our innovation innovator, council mentor. He's an advanced level ambassador. He is our great contributor to our institute regarding innovation. So I think it's a very good chance. And
Honored to have an interaction with you, sir.
Thank you,
Please.
sir. Thank you. Thank you, ma'am. Thank you. Thank you a lot. Ma'am,
go ahead, sir. I think we can hear you, sir.
yeah. Ma'am, after filing the post patent, so what are the requirements we should follow?
After
Mandatory
filing
things.
the first patent.
Yeah. So mandatory things, what we should follow?
Sir, it's actually during the filing of the patent. You have to file numerous forms like Form 1, Form 2, Form 3, Form 5, Form 9, Form 26, Form
Yes.
28. There are 9 to 8 forms if you have filed a patent application through a legal attorney. He files all these forms, and once you have filed, these are all the legal concepts. That's why I say to sir that it's never a possible case through an inventor. We'll need a legal attorney. There are so many forms and filings involved, and internal links and legal concepts involved. Once you file the patent application, then there is no legality left, only the procedures are left. Then you have to get it published, then you have to file again one form to get it examined, then you have to prepare the response to whatever objections are created, and after till every 6 months you have to file a form at Indian Patent Office that where in which all countries it has been filed. If it is filed in only in India, then you have to clarify this that it is filed in India only. So there are so many concepts involved and depends on case to case.
Okay, okay. And also we have some confusion about the declarations.
Declarations, yeah,
Yeah.
I must state this. Oh, this is a good topic. I want to make you all understand the difference between an inventor and an applicant. This is a declaration that people are not aware of the difference between inventor and applicant of a patent application. An inventor is a person or a group of people, maybe one or more, who have done the research work, who are behind the conceptualization of the work. And an applicant is the person who will be owner of the patent, who will be having the patent rights. This is applicant. This may be same or may not be same as the inventor. Inventor and applicant names may be same or may not be same. So if you assign your work to some any other individual or any other department or any other organization, they will be the owners of that patent. They can use it in whatever way they want. So this is declared during the filing of the patent, that who is the inventor, who is the applicant. This is very clearly stated. I
Okay.
hope this makes it very clear.
Yeah, yes, clear. But nowadays, very popular about the Instagram and WhatsApp group. They are we have an idea, so we are going to file the patent. So if you want to join with us, so they they
There
are
is so much happening like this, and
yeah,
I really don't believe in this. I really don't believe in this.
yeah.
Exactly.
This kind of activity, how we are going to see it, ma'am. So what
See,
would you like to say in our faculty members?
see,
Thank
I
you so
would be
much,
very
Kanayaraj
open
sir,
in
for
this.
asking this
I would be
question.
very open in this. There are similar kinds of requests we are getting that, ma'am, we want a patent, please group up and all. We don't believe in this stuff. And what we believe is that I would always prefer do some research work and get it patented by us. And if at all it's like people have collaborated and say they have entered their name in any work they are not even aware of. They are not even aware of that work
Yes.
and they are gladly putting their name into it to get it published. That will never be granted. That will never be granted because that is not a work. That is not a work. That is something fake. So I just want to say, if you are not having trust over your invention, that will it be patented or not, just leave that burden on us. We will do that for you, but at least do it on your own. We have got BTech works also granted. What is the level of BTech students? They have just entered into research. They are so new, they are so novice in research and all. They have just completed their curriculum and they have done some kind of very preliminary research, and we have assisted them to get a publish and then subsequently get a grant. How we are doing, we are getting their work and then we are doing it. We are not saying that we will do it and then okay fine, you just put in your name. What we do is sometimes we say whatever is the final year project report work of the BTech students, you just submit it to us, although those students have passed out, but then they have done some work. This is their hard work put into those final year research report works. we convert them into patents because we know how the things are going on in that final year project report work. But it's at least this kind of trend which you are seeing on the internet and all, we don't believe in this, because what third party is doing, you are just entering your name. That's nothing of no use. You just provide me with the btech year final year projects now that every faculty has, we will get it done for the novelty search. We will optimize it in collaboration with you, and then we will file and get it published. Why not do that way? Why not work that way? Please don't even have a little bit of insecurity in your mind that this work cannot be patented because this is done by students and maybe not of that level. Maybe we make it up to that level. This is our responsibility. We work in our collaboration. I have worked with many. We say that we have to modify it a little bit, we have to optimize it a little bit, we have to work in this direction because this is something which is already in the prior arts. We have to optimize it by including this and that, and then maybe then we can get it published. This will be easier for us to get a grant over it. Obviously there is a chance of having it granted or not, but still we are working on what has been done by you or your faculties. So that's the best part.
Yeah, thank you, ma'am. Thank you. Thank you.
Yeah.
Thank you to Dr. Kanagaraj and also to the ma'am for addressing these very important questions, because it's
Thank
like
you so much. And
it's
in
like
fact, sir, yeah, if you have any other
actually a
questions, you can
expert like
always,
you.
call me up for all those questions. There is no problem, sir. Yeah.
Sure, ma'am, sure. Maybe I think, ma'am, you are. I think you already we crossed the 30 minutes more than what we planned. Should we finish this meeting? And maybe if I have the list of questions, maybe I will ask you personally how we will
Definitely,
proceed.
sir. Definitely, sir. And we can also discuss on how we can further next year in 2022 come up with very great patents from Rathinam College.
Yeah,
And
sure,
not
ma'am.
only
Sure, ma'am.
patents, but also trademark copyrights and trademarks from incubation centers, and
Yeah,
copyrights and designs of all the creative and literary and artistic works done by the, creative team of Rathinam College. Yeah.
sure, ma'am. It's great hearing your speech on IPR, ma'am. It's really, we learned many things. I'm truly speaking. You just opened the secret, I would say. So, really, thank you for this beautiful seminar. Definitely, our faculties have learned and they will take something from you, I'm sure. Maybe we will discuss about how we will proceed in the next steps. Thank you.
Yeah, we can have a meeting with the reputed and honorable decision makers of the college.
Sure, ma'am. Sure, ma'am. Sure, ma'am. Definitely, ma'am. And once again, I thank you, ma'am, on behalf of Rathinam College of Arts and Science. I thank you for accepting the invitation and delivering this wonderful speech. It definitely helped helpful to us, and maybe we hope to have a collaboration with you. Thank you, ma'am.
Yeah, sir. Thank you so much. Honored to have an interactive session with you. And I leave the session with these words. Thank you so much.
Thank you, ma'am. Thank you, faculties, for joining this wonderful session. Hope it would be useful. So maybe we will meet soon in the next seminar with similar expert. Thank you so much.
Thank you, sir.
Actually, sorry, I think Velumani is there. I'm sorry. Maybe just maybe we will try to speak. Thank you, sir. Srinivasan, sir. Thank you so much
Thank
for
you,
your
sir.
Thank you, sir.
support, sir.
Thank you, sir. Thank you, sir.